Hey, folks, can y'all hear me? Can you hear me? Let me know if you can hear me. If I can get them thumbs up or them likes. Sorry for the delay. Y'all can hear me? Okay. Thank you, Little Red. All right. What it do? Let me go through and speak to the folks that's here. Hey, Valencia, Mocha Duchess. Hey, Wifey. Hey, Karen J and Little Red. Honey, I have been, pulled in. I was trying to get some workout, trying to do this, that, and the third, trying to peep in on the lives and all this here. It's a whole bunch of lives, baby, just still going and running and running and running, honey. But let me give a shout out to the messy ass person on. Y'all can hear me? Okay. What up, Tate? Let me give a shout out to the messy ass person on Team Kills. Without you, I wouldn't have been able to catch some of the transcript, right? So somebody on Team Kills, I'm not gonna say who it was because that's not what I do, says that Angie, Diva, and the lady over there is taking a shot at you, talking about a reaction from a real lawyer. Now, obviously, I know how you motherfuckers get down. So obviously, I'm gonna do some goddamn research or whatever. Come to find out, that lady has been naming her segment or something like that for months. Go look at the title. That's not a jig at me. And if it was, I don't give a damn. Because I can always say to anybody that says anything, I guarantee you, you can't do what I can do, and no one will hire you to do what I can do. How about that? So shout out to the messy motherfucker. Because without you, I wouldn't have caught part of the goddamn transcript that we need, that I like to hear to confirm the shit over here that we have been investigating, you know, digging through the goddamn mud and shit, coming up with it as we do on the spot. So good, thank you. you know, and while you at it, I mean, I hope you listen to the whole thing because I was pulled in all these different directions. Um, I still have some stuff out that I have a question about that I didn't get a chance to listen to the transcript, and I don't have the transcript. So, I mean, I knew, as I told you, wasn't going to address everything that the defense was challenging under the uncharged acts because she has a reserved ruling that's out. So that's going to address the rest of the outstanding items. But shout out to you with your messy ass. All right. But keep it coming because if it wasn't for you, I wouldn't have been able to go and get a listen to the pieces that I was able to get. So thank you for that. What else I want? And also, I don't react to nobody else's bullshit or whatever. If you ain't talking to me, I don't address it. I don't have nothing to do with it. I don't fight other people's battles. All right, not doing that. Good luck with all of that. So I don't want to hear about what nobody is summoning me to do. That's not what I do. You do it. That's what you do. You do it. All right. Unlike some people like to, if they have a problem with a certain group, they want to say a certain group got a problem with all the people in the group and whatever. No, I'm an individual type chick. If I have a problem with an individual in a group, that's I have a problem with an individual in a group, not all of a group and all that kind of shit. There's no information or whatever I have to disclose about nobody or no particular group. Ain't got nothing to do with that shit. I will go and come as I please. No one tells me what to do, and those who pay me don't tell me what to do. You got that? So it doesn't matter. That shit you can hash out on your own. But nobody has time for that bullshit. People, believe it or not, I'm professional in professional setting. Okay? Now let me give you an example. Thank you for calling. This is Angie. How may I help you? Oh, that'll be great. About 9? All right, thank you. And call once again. Have a great day. Goodbye. See how I go in and out with the shit? You thought somebody that was somebody else, didn't you? So leave me the fuck alone. Shit. I ain't got time for that shit. We got to get to the tapes. Yeah, that's what the people come here today to talk about the tapes. Now, Team Kills, you might want to be someone listening about this shit here, because we're gonna talk about these tapes. But again, I was glad to listen in on to be able to listen in on part of that goddamn transcript, and I didn't get a chance to listen to all of it because there's all kinds of shit going on, honey. They got a marathon on what is it, Cash Jones, Angelo, and all that. Yeah, so we're gonna, and that's perfect because I wanted to talk about the parents anyway. So I got that keyed up. So I see a few more people that came up in the building. What's up, Angela Jackson? Oh, I don't know. Angel Jackson, I don't know you. Thank you. Hey, Tim Heron, thanks for coming on through. I said Tate and Little Red. All right, so we're going to get into the parents, right? Because there have been some rumblings or whatever, or some wishes and people calling to subpoena parents and all this, that, and the third, which we've always said damn near 2 years ago, you're actually effectively saying he's guilty. And I told you a couple of lives ago that the parents have to have evidence that would be admissible. And that evidence have to be relevant, reliable, and relatable, right? Have it be some of some importance. You know what I'm saying? Has to connect. All right. So, child, let me wait. But shout outs to that goddamn transcript, baby. I'm trying to tell you, it confirms some of that goddamn digging through the crates ass work we be doing over here, baby. It has confirmed some shit for your ass. Well, let's get to these parents. So we're gonna do a little reading. And when I get finished reading, I'm gonna come back on screen to tell you what my summation is. All right. All right. And for those, I'm sorry for the delay. But you know, y'all can catch us on the replay, honey. But I have to get in when I get in. All right. Let's see. All right. So we want to read about the portion that pertains to the parents, right? And of course, you know, they're talking about, most people out here talking about the parents of, I think, Jane Doe number 5, allegedly Jane Doe number 5. But there's some other parents that are mentioned in here. So let's read what it says. It says, the defendant should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of certain victims. Certain racketeering acts and substantive counts allege that the defendant coerced minors, including the individuals identified in the indictment as Jane Doe number 1, Jane Doe number 2, Jane Doe number 5, to engage in sexual activity prior to their being old enough to legally consent to such sexual activity, which is no such thing. All right, because you can't consent as a minor. All right, to prove these offenses, the government expects to present evidence showing that Jane Doe number 1, approximately 15 years old, Jane Doe number 4 at 16 years old, and Jane Doe number 5 at 17 years old spent a substantial amount of time with the defendant, despite having not completed high school, and that the defendant may try to deflect the blame for his criminal conduct by offering evidence that the parents of Jane Doe number 1, Jane Doe number 4, Jane Doe number 5 knew or should have known about their daughter's sexual relationship with the defendant. Now I'm going to stop here. And I'm going to go on the limb to say this. And just know that all of us do everything different, whatever professions we are in, right? Okay? No one is, you could say, you could talk to yourself as an expert in certain areas, what have you, depending on, your education and your job performance. Let me say performance, not history, because your performance will make a distinction between an expert and just a motherfucker that's employed there, right? So, like somebody was pointing out to me that like Judge Joe Brown didn't know what a Kershaw hearing was, and yeah, all type of stuff. So it's what it is. Like, I mean, I want to give just a short story. Like, I can remember, like, girly stuff is just not my thing. I don't know if you noticed that yet, but it's just not my thing, right? I'd rather be sitting in a gym, a hot gym, looking at a game or something. And I used to hate when my daughter used to get those projects that required you take your ass into Michael's. Boy, they give you that goddamn face sheet with all that shit on there, and right then you could tell by the first couple lines you got to run your ass over there to Michael's. And I know it's probably a lot of you Martha Stewart ass people in the chat or whatever that know how to do all that shit with a glue gun. I bet half of y'all got a glue gun sitting by somewhere. And but I'm trying to tell you, the time I hit that door at Michael's, it seems like it's buttons everywhere, feathers, fabric, goddamn, all kind of rocks and shit like that, and paint and all kind of shit, and I be confused. I don't have time. Michael's is not my store. I'm impatient as it is, so I'm gonna grab the first goddamn person I see with a name tag on and give them the list. Hell, because that just shit that I hate them kind of damn projects. Hate that shit. Ah, damn, I don't like Michaels. It's too much. But I said all that to say this, which don't tie into nothing I'm going to talk about. First of all, you can think from that verbiage in there that I just read, you could think your friends and family on YouTube for that. I believe. Because ain't no defense finna go in there talking about the parents told them to have sex with R. Kelly. Not unless they on crack. So I'm thinking they've heard the ramblings and all that shit by watching these channels and stuff, and kind of figured out that they may come with this defense. Don't know why no one, a lawyer that has a license and shit. And here in Florida, our bar number 6 digits, but I don't know what the hell, huh? I'll say like a light joke. Did you take the UVE? Hell, I mean, what the fuck? Who will go in there with this shit? But I'm just thinking that they heard, from the rallies and all kind of stuff, and listen to what people say and all this, and some of the shit that's going on as we speak. They probably thought that it was pretty good to put this in there. It's gonna do a couple things, right? If somebody pulls this up or whatever, it's gonna already put out there that ain't no goddamn parent can say that they can give consent to have sex with no goddamn they child. You can't do that. You can give consent to get married in certain states and stuff. And one is reasonable to think what comes after you get married somebody, if some parent gives consent, you don't really want to think like that. But it has happened. So, but I'll say that just by reading that. All right, we read. Let's see. The defendant may further assert that to the extent the parents of Jane Doe number 1, Jane Doe number 2, and Jane Doe number 5 knew or should have known about their respective sexual relationships with the defendant, the parents thereby consented to such relationships. Even assuming arguendo, which means amongst many things, or other things, that there was evidence to support such claims. The evidence would have no legal bearing as to the offenses with which the defendant is charged. Indeed, consent by either the parents or the underage victims is not a defense to such charges. All right, so right there it says, even assuming arguendo, that there was evidence to support such claims, meaning that they don't have evidence to support such claims, right? They're saying like the defense isn't saying that, but just in case they do, just in case they hit crack that day and come in there and say that, we just don't lay it out. That makes no sense. It says, accordingly, the defendant should not be permitted to elicit testimony from the government's witness, including Jane Doe number 4 and Jane Doe number 5, during cross-examination, introduce evidence or argue that the parents of the women and the girls who the defendant coerced to engage in sexual activity were aware of, consented to, or were otherwise responsible for such activity. Such arguments are legally irrelevant and would only serve as a distraction to the jury. Reference. Irrelevant evidence is not admissible. Reference. If evidence is not admissible where the risk of unfair prejudice substantially outweighs any probative value of such evidence. Similarly, the defendant should not be permitted to introduce evidence of any schemes by the parents of the victims to profit or otherwise extort the defendant on account of the defendant's relationship with their daughters. Specifically, Jane Doe number 5 has advised that her parents proposed certain business ventures with the defendant whereby they stood to profit if the defendant agreed to such business ventures, and while she was still 17 years old, encouraged her to take photographs of the defendant, which could later be used against the defendant given in part her status as a minor. So we do recall hearing that on some type of interview or documentary or something like that. So I'm just going to take a guess that the prosecution is trying to head that off just in case that is introduced, right, as a part of the defense's story of what is their defense. And that stuff can be admissible. As discussed above, the actions of Jane Doe number 5's parents have no legal bearing on the defendant's guilt as to the alleged crimes involving Jane Doe number 5. Accordingly, the government respectfully submits that the defendant should not be permitted to elicit any testimony or otherwise introduce evidence regarding any of the parents' involvement in the business ventures or any means to profit from the defendant. And there's a reference there. So, I'm coming back on the screen. So, what do y'all think about that? Hey, Mrs. April. Hey, y'all. Who came in? My Queen K, Chanel. Thanks. Oh, Brooke the backpack bum bitch. Oh, like Brooke to support my arts and crafts. Okay. Hey, Kayla. Take let's see. Can somebody get rid of what is it? Brooke the backpack bum bitch. What up, Debowski? All right, can somebody take care of that person? That's so nonsense. So, anyway, and I mean, there's nothing that the parents can contribute to the case with regards to that could be if they spoke about any type of deals and stuff like that or whatever, right? Because I'm pretty sure the prosecution will head that off. And as you always know, we always say if you're talking about where were the parents, you're actually saying that there's some kind of guilt. Because if you're calling somebody, because you're actually saying that there were some minors that were around RSK, so there must be something nefarious happened. That's what you're saying. So you're calling them guilty. Now, I mean, I believe that maybe the parents could give limited testimony as to how their child became, familiar with RSK, if they were involved in that, if they had direct knowledge about that. But all of that extra stuff, I doubt that. I mean, and I don't think the defense would want to challenge that anyway. What up, LaKendra? What up? So that's what I would say about the parents. I don't think that, you know, I just, no. Uh-uh. All right. We're going to get to, so let's get to the part where I did catch about the dang on transcripts. And then we're going to get to the tapes. And that's what y'all want to talk about, the damn tapes. Where's the tapes? Where are the tapes? Let's get to that damn transcript. So, um, that's that. That's that. That's it. That's that. What is this? Uh, I'm coming, y'all. Let me just see which. So, listen, right? Check this out. Remember a couple of lives ago, what did do, JoJo the Rhyme? What up, Matisse Bello? Okay, so y'all remember a couple of lives ago, right? I was just trying to figure out, or we were trying to figure out, why the challenge to Jane Doe number 7, 9, 11, 12, 14, and 15, right? So we know it was a reserve ruling. We could tell that by the transcript. I already knew that because it said it in the let me see. I think it was one of the oppositions from either side. I don't know which one. But they referenced a reserve ruling. And a reserve ruling again means that the judge ruled partially on one part of it, the other part is to come at some point, right? So, and you could also kind of tell that because the defense is still battling with those items, right? So, and I said, and I went through, anybody, y'all let me know if y'all remember this. Somebody in the chat, let me know if y'all remember this. So, and I said, then what's the issue? Why they're not battling before eight, Jane Doe number 8, 10, 13, 16, 17, 18, 19, and 20 under the uncharged acts, right? And remember, I saying, well, maybe it's probably because it's some type of direct evidence, some type of evidence. Because I went through and I named off the evidence. Remember, I said number 8, there's evidence of a pamphlet. Number 10, there's a photograph and a an autograph, I believe. Number 13 has an autograph and the bus driver. Number 16, 17, and 18, they wrote letters that the government has. Number 19, they have text messages. And number 20, they have a video threat. Right? You remember that, okay? Thank God for them goddamn transcripts. And to the mess ass person on Team Kel that made me go over there to, to see what the hell was going on. How about I'm not the damn judge, but the judge, y'all ain't gonna believe this him, has, and this is all that I can get, so I don't know what the other people, but the judge has ruled in the favor for the prosecutor to let the evidence, the evidence is under the uncharged acts to be allowed in for Jane Doe number 1, 8, 10, 16, and 17. I don't know if she spoke about Jane Doe number 13, 18, 19, or 20. I don't know. So, but yeah, so it's in. And the judge was citing what? Because it's direct evidence. Boom, pow, boom, boom. Yes, that's what it was. So it wasn't exactly that they were. I was wondering why they wasn't challenging anymore because we didn't know it's a partial. We didn't have a transcript, so it was a partial ruling. We didn't know what part, but I could tell that they kept arguing about 7, 9, 11, 12, 14, and 15. So she must be still. That's the reserve ruling is on that. I don't know if it's on 18, 19, 20, and 13. I don't know. But those Jane Does have some type of um, direct evidence. It could be direct or indirect. And also indirect evidence can be admissible as well. So, yeah, boom. So that's what the hell is going on with that. So I did get that the the audio of the beating would be admissible. The text messages that was in the uncharged act, that would be admissible. And they're not going to allow questioning with regards to the mental health, with the mental health. So that's that. What the defense win was the they can't bring up, well, they can't, I'm not saying they can't bring up, well, the prosecutors can't bring up what happened in the 2008 trial. So I think that's what she said. I don't have time to go back and listen, but that the 2008 trial, I don't know if, well, I have to look in the uncharged act to see what they wanted admitted about the trial. Is it the results, what happened, whatever, or anything about that case, or what, I don't know what parts they tried to get admissible in. So, but yeah, so the defense, whatever it was with regard to that in the uncharged act, and I'll go back and watch and look for it after I get off. They the defense won that. So now it's shaping up. This case is shaping up, right? Because she's letting a lot in. It's the jury situation. Okay, because that's when I didn't know if it was what the situation was with regards to it. I was just able to catch a little bit of it because I was trying to see what the hell is going on with this cash and this story, right? What's going on around these streets? Because when everybody started reporting on something going on with it. So I'm trying to figure out what the hell is going on. Yeah, so that part they're not going to allow it. So I was like, oh, okay, so they got to win. So now it's shaping up. Because it's like their ass, this is going to be, this is going to be some shit. Oh, let me tell you this one time. Tape. All right, so let's get to these tapes. As I told you earlier, I was in Debo's chat. And Debo, by the way, you're still wrong. If you're still in here, you are still wrong about that venue. I told you what it was. The government told you what it was. And the defense told you what it was. That ain't got nothing to do with moving nothing. Asking about moving no venue to no Chicago. They were trying to challenge the jurisdiction by saying that some of these acts happen elsewhere. They're trying to say, why is New York? That's what they're basically trying to say. Why is New York processing the case? Just trying to find anything, any way to say, okay, as if the judge wouldn't know that most likely New York filed for jurisdiction, whatever crimes happen, filed for the jurisdiction first. I told you had the RICO benefits from something called enumerated powers, which is the regulation of interstate commerce for non-economic reasons, right? So they can do that, and it's RICO. So that was a moot point, and that's probably why the last response from the government is so limited with regards to that, because anybody should know that. But anyway, I was in his chat, and we got to start reading them damn footnotes on this paperwork that keeps coming by, because it is a lot. It is a lot that's going on, and it's some important stuff tucked away. So, with that being said, we're gonna start talking about them damn tapes. And I went ahead and did a lot of the leg work in an effort to save time, because, and I'll breeze through it real fast. And Team Kale, this might be something you want to listen to. Woo! The tapes. Where are the tapes? Where are the tapes? Let me see. All right. Let me get this up. Okay, so let me get this document up. Let me put this up on the screen. Where are the damn tapes? Where are the tapes? Where are the tapes? Where are the tapes? Is it this document? All right. I know y'all don't trust Debo. I want y'all to make sure y'all know I ain't lying to you. Right here, it says, in addition, the defendant appears to be under the mistaken impression that witness testimony regarding certain facts, including the creation of visual depictions, is not evidence. He is wrong. So, it tells us that there ain't no tapes with regards to Jane Doe number 2, 4, and 5. Like I was trying to tell Keller, there's no way in the world an attorney gonna sit up there and say that the tapes don't exist if they do. It's just not gonna, that don't make sense. Okay? Now I'm gonna reserve that, my opinion on that, till later, because, but, and maybe, you always got to leave a little room for someone getting it wrong, right? But apparently it's witness testimony. And we're gonna go see if that's what it is in the Uncharged Act. We're gonna see if it's witness testimony. All right. Let me see. Okay. All right, let me put the other one up. We're gonna see, is a witness testimony what they're claiming. Jane Doe number 2, 739. All right, let me get that one up. 739. And we read, okay, we're going to see Jane Doe number 2 is on page 5. Yeah, okay, we're going 5, 6, and 7. Good. All right, Jane Doe number 2. Let's see what it says. It says Racketeering Act 2 alleges that Kelly, together with others, enticed and coerced Jane Doe number 2, a minor, to engage in sexually explicit conduct and then visually recorded such conduct. She alleges. That's testimony. The defendant met Jane Doe number 2 in or about 1999 when she was 16 years old. after another member of the enterprise approached her at a fast food restaurant and informed her that the defendant wished to speak with her. Thereafter, while Jane Doe number 2 was a minor under 18 years old, the defendant filmed their sexual intercourse on multiple occasions, thereby creating child pornography using materials that had been mailed, shipped, and transported in interstate and foreign commerce. It's an allegation. It's not a tape. Jane Doe number 4. Racketeering Acts 5 through 7 allege that Kelly, together with others, enticed Jane Doe number 4, a minor, to engage in illegal sexual activity, made a visual recording of such sexual activity, and used force and threats of force to obtain sexual services from the minor. In or about 2009, when Jane Doe number 4 was 16 years old and the defendant was in his early 40s, the defendant began a sexual relationship with Jane Doe number 4 in violation of Illinois law, which ultimately lasted for a period of months. During this time period, on multiple occasions, the defendant produced sexually explicit photographs and videos of Jane Doe number 4 engaging in sexual intercourse and sexual contact with the defendant and others at his direction. And I'm just skimming through this to see if I have to read it. That's the allegation. She alleges. Jane Doe number 5. Racketeering Acts 8 through 11 alleged that Kelly, together with others, enticed Jane Doe number 5, a minor, to engage in illegal sexual activity, made a visual recording of such sexual activity, and used force and threats of force to obtain sexual services from the minor. Counts 2 through 5 charged the defendant with standalone crimes involving certain of that conduct to Jane Doe number 5. Okay, we know that. In and about 2015, Jane Doe number 5, a minor and an aspiring music artist, met the defendant after attending one of his concerts. Thereafter, at the defendant's suggestion, Jane Doe number 5 began traveling on a consistent basis with the defendant while he was on tour at the defendant's direction, purportedly to learn about the music business, including to various locations in California, while Jane Doe number 5 was under 18 years old. That's allegation. It's not a tape. Right. Right, Karen J. Thank you, baby. Thank you. See how they do it over here? See how they do it. If y'all, I meant to tell y'all, if y'all have y'all paperwork or whatever, y'all can read along with me. I'm back on the front screen. Those are allegations. So now my little margin of error is closing, right? Because it says alleges. On the footnote by the government, as well, it says testimony, which is an allegation, testimony, which can be an allegation, right? Which will test, an allegation would be a testimony. An allegation can turn into testimony, right? So yeah. So that's what we don't call. So Team Kales, Team Kales, Team Kales. Give them hell, Team Kales, give them hell. Give them hell, Team Kales, give them hell. Yeah. And sometimes you got to reread it, whatever, because I caught that alleged word just as I read it just now. I was looking through that and look for, visual depictions or that like they had evidence or anything like that, right? I caught that alleged word as I read it. It's an allegation. That means testimony. So they have a pretty good challenge on that. But here's the thing. That is somebody taking a stand, giving testimony. Now, if 245 don't take the stand, then then it kind of, but you won't know that until trial. By that time, this would already be ruled upon, right? I mean, so you would think, right? But it could be, you know. So yeah, that's what that is. So now we're still gonna talk about some tapes because we need to find out what about these tapes. Okay. So what, and that will take us to the Chicago case, which we should be kind of leaning to focusing on that now. This is about, this is already pretty much tied up, right? And we're waiting on a couple outstanding items to come in from the judge. Once we get that, I'm pretty sure this will be buttoned up. So, but we still got an issue with the tapes because it has been thought that the girl that is mentioned, the minor that's mentioned in the Chicago case is minor one, is allegedly somewhat tucked under this case with New York, right? If that if somebody let me know, y'all, if that's the truth. Lord, what is he doing? Y'all always okay. All right. So let me know, y'all. Is it y'all understanding that the minor one in the Chicago case, if you're familiar with the case, because I'm not familiar with these cases. That's why, I'm sorry y'all for the reread, but I have to get it like that. If y'all can tell me if minor one in the Chicago case appears in the New York case. Let me know if y'all know that. Because that'll save me some time. Because I'm thinking that, and if y'all think she's in the, let's see, where is Keep when you need her? If you think she's in the New York case, then which, right, 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 okay. So she's definitely not Jane Doe number 245. So this is crazy, right? So let me show y'all the indictment for New York. And we're gonna see if she's in there. Let me find that one. Let me see if she's in there. Okay. This is 653. All right. Here's the indictment for New York. Indictment for New York, right? Now, I went ahead and did some of the legwork through the Chicago indictment to save time. But per the Chicago indictment, it said that this minor 1 met the defendant in either 1996 or 1997. All right, so let's look for 1996 and 1997. Okay, let me look for 1997. I don't get nothing. That's 94. So maybe she's not in. So maybe, hold on. I know I can solve this problem really quick. Hold on, I can solve all of this. Okay, so it's not. Now this Jane Doe number 2. Is it Jane Doe number 2? That's the only thing. Hold on. Could it be Jane Doe number 2? That was the leading. That was what everybody was thinking about before. Could it be Jane Doe number 2? That the date. Okay, because in about 19, both James Brown Parks and Orange's defendant together with others. See, if okay, this is when in May 1999 and October 1999, that's when the oh yeah, that's when the visual depictions began, right? 1999 and yeah, 1999. But they met in 1996, so we don't get a backstory on that. Hold on, let's find out if it's Jane Doe number 2. Now this part I didn't do. I should have did this part of it. Let's see. Okay, let's see. Okay, that sexual exploitation of a child. Is there a backstory? Hey, that's it for Jane Doe number 2. So Jane Doe number 2 could be minor number 1. So it can't be her. Let's see. Jane Doe number 2. Okay, let's go. Let's look. This is what we do. Okay. How old was Jane Doe number 2? How old is Jane Doe number 2? All right, let's see if we can find that out in. Hold on, let's see. I already got it keyed up, honey. Hold on. Let's see if we can find that out in this. Okay, this is all right. And where we at now? I'm gonna need y'all to do that math. All right, so minor one in 1996, 1997. Minor one was approximately 12 or 13 years old. Which would have made her okay. They say 96, 97, approximately 12, 13 years old. All right, so that's one day. Okay, so that would have made minor number one 15 years old at the time of the crime, right? At the time of the crime. At the time of the crime, 1999 or 99, she'd been 15 years old, right? Aren't they hard on that 99? Let me see. Aren't they hard on the 99? It's not a on or about or anything like that. Yeah, it's hard on 1999. So she would have been 15 years old. Who was that? Team Kales, Team Kales. Give them hell, Team Kales. Who was that? Let's keep looking. Where the tapes? Where the tapes? Somebody tell me where the tapes. Anybody got the tapes in the chat? Where the tapes? Where the tapes? Ooh, tell me where the tapes. I'm up all night trying to find the tape. I ain't on the motherfucking tapes. I'm on the phone. Where the tapes? Where the tapes? Where the tapes? Where the tapes? Let's see. Let me see. Let me see. I'm steady looking. Okay, okay, okay. All right. I'm looking in the. What am I looking at now? Oh, all right. So let me put that second book they put up there. That motion to eliminate. They hit him in the head with the prosecutor hit him in the head with um and see what that says. Let's see if anything tucked up under there because we haven't paid that much attention to that long ass emotion of eliminate the second one the government put in, but let me see if there's anything tucked under there. Where are the tapes? Where the tapes? Where the tapes? Where are those tapes? Got us looking high and low for the tapes. Where are those tapes? Okay, let's see. Dom K in the building. Dom Kang in the building. Dom Kang, what the tapes? What the tapes? What the tapes? Let me see. Somebody better show me the tapes. Okay, let's see. Trying to get it up here. I'm getting it up here. I'm getting it up. And I got some damn documents open. see what they say under here. Okay, let's see if we can find some about some tapes in here. Visual depiction, I believe that's what the word they're using. All right, let's see video. Are they using that word? Okay. It's only where video appears. What about tape? Nothing about a tape. And the tape's not in there. Okay. So, tape's not there. Minus one in Chicago would be, should be around 15 years old in 1999. 1999 is when they said the thing happened. Am I right? Isn't that what it said? For Jane Doe number 2. Said 1999. That's the only thing that's in that age, that time frame that would make sense, right? Because if they met around 96 to 97, 99 would be the time frame of the tape. Hold on, let me get this back on the screen. So y'all can see what I see. This is a singing live tonight, honey. Singing live. All right, let's go 6:53. And you know we'll break it down. We breaks it all the way down. All right, let's look at the date. This is the last indictment, right? 94. We already know who that is. Okay. 99, 99, 99. That's it. That's 2003, 2004. Three and four. 2009 and 10. It's going in order. 9 and 10. 2009 and 10. And I'm looking under the dates for the acts. 2015. 2015. I ain't got the lie, Craig. 2015. 2015. 2015. 2015. 2018. It's going in order. So where the tapes, where the tapes. More important, where the Jane Doe, where the Jane Doe. Where the Jane Doe, where the Jane Doe. Somebody tell me where the Jane Doe. What, like, y'all in here killing each other as usual. I'm looking up at the screen now. Y'all in here killing each other as usual. Hey, Justice Don't Sleep. What it do? Let me holler at a couple of y'all. Dom King is in the building. That's on the tape. Right. Woo. What up, Take? I think I hollered at you. What's came up in the building? James Harris, Mark Queen K. Let me see. And everybody looking in. And my wonder. What's up, Kayla? James Harris. I said, hey y'all. They say I get all the men over here by enticement, by enticement, and this lovely rough ass voice. Hey, Joanne Reynolds. Right, Joanne. Yeah, just people trying to start drama, child. I'm like, well, I'm glad they did because I'm going over there and hit a goddamn transcript. But I got to go back to maybe try to get the rest of it. But yeah, so it's safely we can say that we can move on from New York and the tape. Is it safe to say? I mean, of course, I'm not on the case. We're not on the case. We just trying to figure it out because we're not gonna know what all they have and all that. We're not just whatever, But it's reasonable to expect that a tape would be mentioned by either party, an actual physical tape that they have as evidence, not an allegation, not alleging that there were depictions. Rather, it could be, and it doesn't even say a photograph. So, no. But I don't think, I'm not sure, but I don't think minor one is in, because think about it. Think about this too. I don't know why the hell I went through all of that. I just went here and did this. If minor one was in New York, in the New York indictment, certainly a video would be there. I don't know why. I mean, sometimes you got to go through it to get through it. You know what I'm saying? So, yeah. So, yeah. So let's go to where the tapes are in Chicago, where you get shot at. You get shot in Chicago. You get shot in Chicago. Let's see. Don't take your ass in Chicago without a bulletproof vest and a helmet. Okay, let me see what we got. All right. We're gonna go to the what? The Chicago indictment. Okay, what's Lil Red's comment? Let me see. Lil Red. What you say, Lil Red? Angie, can you get the transcript from August 19th, 2020? They mentioned CP. All right. Is that New York? Or is that August 19th, 2020? Hold on. Is that New York or Chicago? Hold on, let me see. I can't see y'all right now. I am. Let me see. Somebody maybe give me an answer. I believe it's New York. Okay, I'm in here looking. Let me look for it. Okay. Right, shut up. August. Um, Let me see. Memphis and Dolly. Telephone conference. Come. And guys, y'all who that have a Pacer account, when you see motions and stuff like that in the system, and right up under it, you see where it says terminated. that means that the judge ruled on it, or judge answered it. So I didn't see it in the New York, so let me look in the Chicago. I don't see a transcript. Is something else? Let me see. Order for motion for disclosure. Let me see. Let me see what this is. I bet it's about the evidence. If I look at that. A minute. Court justify kill the motion disclosure to take order. I didn't see it in here. I didn't see it in here. So but I'm glad you did say something about a transcript because I had to pull one up. I'm gonna turn to let me put this on. I didn't see that transcript, so maybe okay. All right, we have the Chicago indictment, right? Which were the tapes are. And we're just gonna prove what we're trying to uncover. All right, so now right here on count one, it says the special made 2019 grand jury charges in or around 1998 or 1999 at Chicago in the Northern District of Illinois, Eastern Division. Defendant herein did knowingly employ, use, persuade, induce, entice, and coerce a minor, namely minor one, to hold on, y'all. Wait a minute. I just thought about something. Hold on. Let me go to count three real quick. Hold on. Wait a minute. Let me see if the tape is him. Hold on. Because that's 9899. When that tape, wait, hold on. Let's see if we don't got the tape. Hold on. Let's see if the tape is there. I'm switching over to y'all can't see, but I'm switching over to the other one. I just caught something. Something just caught my eye. Well, I'm trying to really now. I'm trying to confirm the girl. Um, and now that's I'm trying to rule out the girl. Put it like that. Okay, this happened on 99 May and October. Count this alleged. Okay, count three is. Hold on. Get my pen. Okay, May and October. 99. So this is 98 and 99. Okay, what count four says that's 98. What about count five? And so I don't think count five had anything to do with no tape. That's about the his co-defendant. So, all right. So there are some tapes. It says in or around 1998 or 1999 at Chicago in the Northern District of Illinois, Eastern Division, RSK, also known as R. Kelly, defendant herein, did knowingly employ, use, persuade, induce, entice, and coerce a minor, namely minor one, to engage in sexually explicit conduct for the purpose of producing a visual depiction of such conduct, namely video one, and defendant knew or had reason to know that such visual depiction would be transported in interstate or foreign commerce or mailed, or such visual depiction was actually transported in interstate for or foreign commerce or mailed. There is a tape there. Count number 2, it refers to minor 1 as video 2. So there's one minor. Count 3 is minor number 1, video 3. Count 4 is minor 1, video 4. And count 5 has something to do with Daryl McDavid and Milton Brown. Okay. So now I did see a list of some more minors. So there's a minor 3, 4, 5, and 6. So minor 1. So who is minor 3? Minor 4. Okay, wait a minute. I need to do something. Minor 1996, 15. Okay. So I'm back on the screen. Now, when I was going through that, this is something I didn't know that you guys probably did already know. That minor 1 and individual D was on a tape together. Individual C and D were the ones who got who were supposed allegedly gotten the tape back and given it to RSK. I also found out, I don't know if this was over a year or so ago, when I was listening to one of the telephone conferences, and I heard them talking about Greenberg saying that there was an issue to sever. And I told you guys when he spoke about sever, he was and I have a video up explaining it, still up on there, is one title talking about the telephone conference, right? When I was explaining that at that point they were trying to either sever like the defendants up, break them up, right? Or sever RSK's cases. And they do that in an effort to not to prejudice the jury with all that evidence, right? All at once. So when I was looking, I just ran across it, and it looks like it was McDavid. It could be also Brown, but I did see that it was McDavid that was trying to, get his situation severed. I don't think, unless he did it after the point I stopped looking, I don't think he ever made application to do so. So it's probably reasonable that they are still going to be co-defendants and all that is still going to be intact. However, there is still a lot of movement that can be made on the Chicago case. So I did pick that up. But yeah. Let me see what else. So yeah. So far we are digging it up. Oh Lord, what Lord Jojo the Run, what is it you doing in there? What are you doing? Let me go and drop this link. Lord, somebody please pray over the link. Please pray over the link. I'm dropping the link. Please pray over the link. I'm going to be doing a silent prayer over here. Lord have mercy. Jesus. The link. Where are the tapes? Where are the tapes? Now, yeah. I was shoot. Let me look at that transcript real quick. Let me see what I was wanting to pick out on the transcript. Also, just wanted to make sure y'all do know. I think I had already read this up here when Kelly was up here. I think this was the same transcript, but let me put that on the screen real quick. This transcript 6017. Let me see if that's it. ECL, I guess it's it. I don't know. Hold on, I'm trying to. That's not what I needed. But anyway, I don't feel like fighting with that transcript. But anyway, so I'll just go and read it to you. It says, and this was AUSA Miss Cruel. It says, Your Honor, the government objects to a severance, right? That's what I was telling y'all about. There are two reasons why the government is not objecting to continuing the trial. The first reason is that very recently the government has executed a search warrant. As a part of that execution, we recovered over 100 electronic devices. There we go. Electronic devices. And those devices are things like iPads and cell phones and hard drives. And there is no way that we're going to be able to analyze all of those devices before April 27th. And that would affect all three defendants. If there's additional evidence on those devices, or there could be Brady or Giglio information on those devices. And we just don't feel comfortable going to trial on April 27th because of that. And the second reason that we are not objecting to a continuance of the trial is that it does appear that in the near future, the government does intend to supersede the indictment again to add yet another victim. So, and I looked in the system and I didn't see where that happened in Chicago as of yet, as well as that's where they are, looks like they are processing the storage, the 100 devices. So, I don't know. What it do, high maintenance, what it do. I see cotton candy. Karen J been up in here. What it do, what it do. So yeah. So I think we can we stop looking for the tapes in New York? Can we stop looking for the tapes in New York? Because we done looked high and low for the tapes. Yes, we done looked high and low for the goddamn tapes in New York. Well, let's see. Oh, okay, I did it in an hour and 30. That's pretty good. I knocked out two jurisdictions in an hour and a half. All right, so folks, that would be my time. I am surely glad we everybody that done came on over to hang out with your girl. Yeah, New York is, yeah, she let some stuff in there. But that's still, I'll give that probably New York case probably a good 83% conviction rate. I'll give it that. I'll give it that in this particular case, being that what she allowed in, that's pretty. But you always got that 17%, and as we know, anything can happen. I was trying to tell you, but I can say we can take the tapes off the goddamn table in New York. We can put that. I mean, for right now, because we don't know what they gonna might hit us with, and I doubt that they gonna sit up there and wait this right to the last moment to come up with some tapes, and the people ain't seen the tapes and this, that, and the third. Then you're gonna have the issues of the defendant, the defense talking about all of these rights and all of this here, and then you got to fight with that for some time. So you don't want to be having to go through all of that, with that late, that last minute stuff and all of that. You don't want to have to be, you know, setting it up for all of that for some appeals and all that stuff to happen in the future, and all that fighting and stuff that will be going on during the trial if that stuff try to walk up in there. So I don't know. Right. We also don't know what's under seal. We don't know. Hey, secret sister, what it do? What it do, lady? What it do? So anyway, I am going to go ahead and close it on out. Thanks again to the host, the hostess, and the guests, and everybody else that came through. All right, till the next time, y'all. Good night or good morning.